after graduating from Cornell, I clerked on the U.S. Court of Appeals for the Sixth Circuit. I then went off and did work at Crowell and Mooring, where I loved practice here in Washington, D.C. But then where I wanted to go was into the academic world at some point to teach. And so I had the great fortune of getting a visiting assistant professorship for 1 year at George Mason Law School, and then moved on to an Olin Fellowship at the University of Virginia School of Law, after which I went on the full tenure track market and ended up at Chapman University out in California for the past 16 years before coming back here home to George Mason, where I'm now a professor of law as well as the deputy executive director of the Law and Economics Center. But one of the thrills in between going to California and getting back here permanently was the fall of 2018, when I got to study as a visiting scholar at the Georgetown Center for the Constitution. And I gave a talk early on when this book was just in a much more underdeveloped stage to all of the students that came to a talk similar to this, but it was live back then when we could still meet in person, and I hope we'll do that again sometime, and I'll get to meet all of you at some time in person as well. But one thing that was wonderful is seeing how many ideas came from that audience that have made it into the book now, and there'll be some credit to those folks in that seminar that we did in the book. And the book is in its final stages of editing right now and should be out by early next year. But there's still some room for me to make improvements. So I'm excited to get some of your comments and any of your questions that might help me to take this in a slightly different direction for certain points. So what are we going to be talking about today? I'm going to pop up a screen, so I'm going to stop seeing all of you, but I'll share some slides to kind of give you an idea of things. I'm going to talk for about 20-25 minutes, and then we're going to have hopefully some robust Q&A for the rest of the period. So this book is about framing the Constitution and the impact of labels on constitutional interpretation. And so what I want to sort of start out with is identify what is a label, what is framing, and why might that matter. In part of this talk, I'm going to talk to you about why it matters more generally. At other points, given the theme of study at the Center for the Constitution, I do want you to start thinking about whether or not labels that we affix to constitutional content help us or hurt us in the endeavor to identify original meaning or otherwise effectuate constitutional interpretation in a particular way. So I'm going to share my screen, and hopefully everyone can see it. Thumbs up if everyone can see it. Yes. Good. All right. So the idea here is that we're going to talk about labels. So how do the extra-textual labels we affix to constitutional rights, powers, and other concepts, how have they been generated? By extra-textual, the reason why I'm choosing that phrase is because there are no labels actually in the Constitution itself, right? You don't have a label that says this section is going to be called this. So extra-textual. And then how do those labels impact, or more precisely have framing effects on, the interpretation, construction, and perception of the quality, content, purpose, value, or meaning of constitutional text to which they're attached. Let me just step back for a minute and tell you how this project started. I am principally a property law scholar. I do work in constitutional law, but I teach property law. I've taught property law for the past 20 years. It is sort of my passion. And I was asking myself, okay, we have this thing called the takings clause. And one thing I wondered was, why do we call it by the power that's limited rather than by the right that's protected? We don't call, for example, the First Amendment speech protections, the censorship clause, or the abridgment of speech clause. No, we call it the free speech clause, or we call it the free press clause, right? We're labeling it by the thing that we want to emphasize. So if you think about emphasis labeling, which I'll talk about in just a moment, we're emphasizing a particular aspect. And by emphasizing a particular aspect, do we heighten that aspect to a priority level? If we're heightening the priority to the power, even though limited, are we somehow legitimizing the existence of the takings power rather than focusing on the property rights which are protected within the takings clause? And the reason why I was so curious about this is because, to me, and I ended up writing 2 articles on why we should care about a right to keep property. You often learn in property class about the right to acquire, learn about the right to transfer, you learn about the right to exchange in property, but you don't learn about the right to keep property or the right to refuse to sell. The right to be free of coercive transfers. And so when I was thinking about the takings clause to the US Constitution, which for those of you who, I shouldn't presume that everyone knows, it's nor shall private property be taken for public use without just compensation. So there's two principal components in that. In the Calabrese and Malamud law and economics kind of language, one is a property rule, the other is a liability rule. So the public use provision is a property rule. In other words, it can be enforced by an injunction. That is, you can say no to the government. You can say, government, go away if they're taking for anything other than a public use, right? You can say, no, you cannot transfer a private use. I have the right to enjoin the government against taking for private uses, which means I can enforce my right there under the public use clause as a property rule. I can enforce it by injunction. Now, in reality, you've all read Kelo or heard about Kelo and the predecessors to that. The government has very few limitations on the public use clause, but nonetheless, it's supposed to operate like a property rule. The second thing that is in the takings clause is nor shall private property be taken for public use without just compensation. The just compensation is a liability rule. That is, once you cross the hurdle of the property rule, it is being taken for a public use, then all you can ask for from the government is just compensation. You can no longer refuse the government. You must allow the coercion to go forward. So what is the takings clause really trying to do? I postured that it was meant to protect the right to keep. That is, the public use clause says, no, you can have a right to refuse to sell for anything other than a public use. And so we're protecting the right to keep there. And then the second is, what is the just compensation component of the takings clause meant to compensate for? Well, it's not meant to compensate really for the property. What little stick in the bundle is lost? The stick in the bundle that's lost is your right to refuse to sell. Right? It's the coercion that's being compensated for more than anything else. So when I first started off on this project, I said, look, it really isn't, the takings clause isn't about facilitating takings. It's about actually providing two levels of protection to the right to keep. And so why aren't we focused on those rights rather than on the power in the label itself? Then I wondered to myself, okay, can I learn some things from a variety of different social sciences, psycholinguistics, advertising and marketing, and other, psychology and linguistics generally, the philosophy of language, about whether or not it matters. Does it matter that we call it the takings clause? And so I started delving into all the framing research and the social science research on why the way we frame something affects the way we view something. And so even if you just think about, if any of you have kids or a little brother or sister, right, or maybe you just have, you remember your childhood, you had some really horrible, paintings that you brought home from school and your parents put it up on the refrigerator. Now, imagine if instead you put it in a really pretty frame, right, a really expensive looking Victorian frame or something, and then slapped it up on the wall. You can call it art, right? And in fact, there's a lot of museums where there's some things that look a little bit like that they call art, and it's really expensive. And if it weren't in that frame though, but if instead it were on the refrigerator, you might just think it was a kid who just doodled a little bit. And so that frame changes your perception of the thing that's framed within it. And that's kind of the essence of the social science literature. I don't want to go too deep into it. We can do that in the Q&A if you want, but that's the basic idea. So if we put this takings clause frame, the label itself creates a frame. If we put that around it, does it change how we view what's inside of it? That is the actual text, the actual meaning, the actual interpretation of the constitutional provisions that are there. We have a few examples. They're on a couple slides in just a moment. We have a few examples, including, for example, that you might recognize, including the idea of the estate tax versus the death tax. All right, so this is where people actually choose to frame the same exact kind of tax in two different ways, one a pejorative way designed to force opposition and one in a more neutral way, estate tax, right? Death tax sounds really bad and it makes this taxation look really bad. That frame in and of itself changes your interpretation of the exact same content of legislation. And there have been studies to show that reactions that people have, depending on which that's framed, they see it as quite different and see, the death tax as, something like the Death Star and Lord Vader is going to come, right? Whereas the estate tax, well, that just kind of seems rather benign. So that's kind of what we're going to be talking about today. And I'm going to run through a few different examples to show you a bit of what I'm talking about. So a bit of what we mean here, the names or shorthand expressions we give to specific parts of the Constitution or to constitutional concepts are really what I'm focused on in this book. I've given you the takings clause example. I've told you why they're extra-textual. You know that they're not in there. There's a lot we can learn from advertising literature about labeling constitutional products. One law professor, when I gave a talk the same fall, but he wasn't there at this talk, and he's not from Georgetown, but at another Georgetown Center for the Constitution meeting that we had, this one professor suggested maybe you should call it Mad Men Meets the Constitution, your book, right? After the TV show, which is some of you may have seen, and about advertising executives. So the idea is that we use this in ways to sort of advertise and tell people what's inside the product, what's inside the cereal box, what's inside the constitutional provision box. So we're going to be labeling all these different things, and I'm really trying to explore a number of different questions. Where and when did labels come from? This was important because this will tell you sort of the trajectory of the book. The book started with, all right, I wrote this article about the takings clause, and then I realized at Randy Barnett's suggestion that I should do an entire book on labels across the board in constitutional discourse. And so we were sitting down at breakfast one time, and I was telling you about the Takings Clause project, and from there the book blossomed. So I really owe it to Randy, Professor Barnett, for giving me the motivation to move into a full-scale book on these things widely. But when I was first doing the Takings Clause project, I had to ask myself an important question. Look, if I'm going to actually say that this matters, maybe I should figure out when did people first start using it, right? Because if the founders were using these labels, then maybe that actually tells us something about interpretation, because they were doing emphasis framing themselves designed to push us in a particular interpretive direction. Maybe if it came up later, I learned something else. Strikingly interesting evidence came out of this. I'll give you just the Takings Clause story, and then we'll talk about some other clauses in the slides after this. So the Takings Clause story shocked me. So let me ask you, I'm going to take the share screen off for a minute. I'm going to ask how many of you some of you may already know this question because you've either read portions of things I have out there or because you've been told. But how many of you think that the Takings Clause was used? I know not everyone has their screen up, so we're really just going to have to do the 6 of you that actually are showing your faces. How many of you think that the Takings Clause was a label that we used at the founding? How many think it was something we used prior to 1900? All right. How many of you think it was something that didn't get used until 1955? All right, good answer. All right, so this was the shocking part. The shocking part was there's no long-standing provenance for the Takings Clause label. The first time any court used it, any court of any kind, state or federal, was in 1955 in the Court of Claims. The first time the Supreme Court ever labeled anything the Takings Clause, and they actually left off the S. The first time the Supreme Court ever used it, they called it the Taking Clause, not the Takings Clause. A year later, they switched to Takings Clause. No idea why. But in any case, that wasn't until 1978 in the Penn Central case. So this labeling phenomenon is actually really, really new. And what I wanted to explore in the book is how new is it for other things? And it turns out it's really new for other things too. Our normal discussion that we would have in constitutional discourse, in Supreme Court opinions and elsewhere, would be the clause which provides. And then they would give full language of the clause which provides, which would actually give greater emphasis to focusing on looking at the language as a whole. This, in fact, is leading, may lead to, I have to admit, may lead to a critique of clause-by-clause analysis that originalism often offers. That is, maybe we're a little too clause-centric in originalism because of the fact that there wasn't so much clause-dependent discussion going on early on. We can have that discussion a little bit more in the Q&A. So I realized that the Takings Clause was one of these things that came up really late. Are there competing labels? Do we call things other things? What are the differences between the labels? Are the labels adopted strategically, or are they just because of efficiency of a shared vocabulary? Do labels change over time? And does the label drive the interpretation, or does the interpretation drive the label? We're not going to have time to discuss all these things, but I'll just give you kind of a sense of some of the questions that the book is trying to raise. I'll leave those up there for just a minute while I talk about one which I think is important to all of you. That is, why are labels sticky? When I say sticky, I mean they stick around, right? That once you start using them, they tend to stick. Part of it is because all of you are in law school taking classes from people who all use the same labels. And in fact, all across the country, we have people using the same labels. And I'm going to try to convince you that some of those labels are at best inaccurate or incomplete in a way that could have a potential deleterious effect on a robust evaluation of the content of the label itself. So one that, if some of you are in Professor Barnett's con law class, you may already have talked about the due process clause versus the due process of law clause, the due process of law. So most professors across the country call it the due process clause, but that they leave off the of law. Well, if you believe of law has substantive content, that is that one cannot be deprived of anything other than law, cannot be deprived of life, liberty, or property without due process of law, meaning that it not only you have to have due process, but it has to be due process effectuated by a valid law. That is a non-arbitrary law that passes sort of the fundamental minimums of what constitutes a valid and legitimate and justifiable law, rather than just legislation. If you believe of law has additional content, then you might say leaving it off forces people, does not force people to ask the question, what does of law do? If you leave due process of law in, it's not only more textually complete, but it is perhaps going to lead you to a more complete discussion of what each word within the label means. Let me give you another one that's really sticky, I think, in all classrooms, and that's Commerce Clause, when we're talking about the interstate aspects of Commerce Clause. So there are sort of three competing labels here. There are more. I actually learned for the first time at my talk here in 2018 to a group of students that in India, what we call the Commerce Clause, they call the Free Trade Clause, even though it has exactly the same basic content in their constitution. And so that label was quite different, and that was new to me. So that's one of the things I learned by this kind of forum. So I hope I'll get a few more tidbits like that to take away with me today. But think of this, the Commerce Clause. Most of you learn that, your textbooks have it called the Commerce Clause rather than the Interstate Commerce Clause. If you keep the Interstate Commerce Clause in there, then you're more likely to ask, well, what extra work does that word interstate actually do? If you take it out and it's just about the Commerce Clause, then you think that this clause is about the power over commerce more generally, when it's not. That's the broad interpretation of constitutional law that goes far beyond the understood limits that the word interstate injects into the constitutional provision. So it's far more fidelitous to the constitutional text to call it the Interstate Commerce Clause than the Commerce Clause. I contend, and I'll show you in a minute, that I'm like the only one in the world who goes around using this. I prefer to call it the Commerce Among the Several States Clause. It's far more textually complete, it's more textually accurate. It's a little harder and longer to say, it's not quite as efficient, but it is more fidelitous to the actual text of the Constitution. I'm going to show you a graph in a minute to show you that no court has ever adopted that. When all of you become judges, you can be the first to do that. In all of your papers, you can start to do that. But the thing is, I'm trying to get, one of my audiences for this book is law professors and law students, to get them to at least make students aware that they may have subconscious effects, subconscious framing effects from the choices of the labels that are being used. And that we shouldn't just continue to use the labels because that's how we learned in law school. But instead, we should figure out what's the more appropriate label to actually use. So, I've talked to you about the rights protective clauses of the Constitution are not called by powers, they're called by we typically adopt labels that talk about the actual right protected rather than the deprivation or the power that's here, despite the fact that you can censor some things, you can abridge some speech, there's limits on it. So instead we give sort of emphasis to all of that. So the point is, the frames we create by the labels we choose have an impact on the substance of the objects they frame, and you see this in art magazines, and you can learn it in psycholinguistics too, but you can just as much talk to people who curate at museums who take great care in deciding how to put what labels to put on what art. If you believe law has an expressive function, then you believe that some of this matters, and just sort of one quick, to make sure we're all talking on the same page during the Q&A, what do I think about, what do I mean by labels? I like this Gideon Karen quote and this is mainly about emphasis labeling, which is the primary focus of the book. That is, the words we choose to put into the label emphasize what we care about most in the constitutional provision. The most prevailing facet of framing is to direct attention to some aspects while suppressing others. And so you suppress others by not including them. You direct attention to the other aspects by including them. That will enhance a particular interpretation and eventually result in a specific response. Different frames evidently direct attentional resources to different aspects by cueing the system toward one or the other attribute. Frames provide cues to infer the categorical identity of a perceived object or an event. Different categories may imply different reference points and different criteria for evaluation. So we are directing attention to particular points. We are emphasizing when we choose the labels. We think that they're really just sort of efficient shorthands that we all get used to, and it's like, oh yeah, it's the Commerce Clause, it's the Due Process Clause, it's the Equal Protection Clause, without really thinking about, are we actually communicating some additional information or failing to communicate important information by choosing to use one label over the other? As I said, I'm going to primarily talking about emphasis framing. There is some equivalence framing in the book. This should not be all that new to you. Lawyers, you are learning this in your writing classes, right? You have to frame your arguments in your briefs. Lawyers get that all the time, and they understand why it's going to matter to the judges. Politicians do it. I've given you some examples of that, and marketers do it. Politics, death tax versus estate tax, pro-life versus anti-choice, right? You see that going on on your screen right now. You watch any news show where a candidate comes up, that you can see exactly different language being used for the same positions, depending on whether or not you want to demonize or make your opponent look bad, or you want to make your opponent look like they have some kind of principled stance. Politicians don't tax and spend, they invest in the country, they make investments in the future, right? These are all ways in which they're trying to manipulate how you view what they're trying to pass off. There's a lot that I could talk about. We could talk about various aspects of the social science literature, but I'm going to sort of skip over that to just say the history of constitutional labels is I think, really important. It's important at the very least from a historical perspective, from a understanding of plain meaning, that we were not using labels for most of our time together. So I thought the chart was up here, and I apologize that it's not. But the basic idea is that for the vast majority of constitutional content, the corpus linguistics and other research has revealed that labels were not used at the founding other than for one clause, the sweeping clause. And the reason why the sweeping clause, which you probably know is the necessary and proper clause, we had a label for it, is because there was a pre-existing label in contract law, which was adopted by some in a somewhat pejorative way to identify the necessary and proper clause. But other than that, and there's very few mentions of it in the Federalist Papers and other places. Other than that, the framers didn't use any labels. You can look at all Supreme Court opinions and a variety of other corpuses across time, and really no labels were being used prior to the Civil War. So labeling is a new phenomenon. It is not something which has generally occurred. And I think I give it sort of a thought experiment. Let's say labeling was happening back in the founding. If, and this is sort of this is at the bottom of the screen. For example, what if during the ratification or early post-ratification era, what we often refer to today as the Contracts Clause had been given what I'm calling a textually augmented label, like the Private Contracts Clause, by those who believed it only applied to private contracts, or the Public Contracts Clause for those who believed otherwise. There's little doubt that you would see people using that label to argue for the interpretation of its scope. They would say, look, they called it the Private Contracts Clause, even though the private isn't in the Constitution. That's what they meant it to. That's where they meant the scope limitation to be. That wasn't happening. That's important in and of itself to know. If you believe that had they used it, it would have been used in constitutional interpretation to try and identify the scope, then you should believe that the labels today could be used in the same way, even if not always directly consciously. Here are some things that the book is studying and ways that we can talk about this. Due process versus due process clause versus liberty clause. Liberty clause has only been used once in the Supreme Court by Justice Stevens in the McDonald case to characterize this. And that was one case where there was clearly a strategic label chosen. I've talked to you about some of the other examples. So I'm going to wrap up by just giving you the categories that I use in the book. If you have ideas of others, they may be in the book or they might not. This is not an exhaustive list here. But textually imprecise labels, sometimes we just don't use the exact language, but we kind of come close. Takings, for example, taken is in the Constitution. Textually selective labels. So faithful execution clause versus take care clause versus execution clause versus execution of the laws clause. Notice you could choose different things from the exact same clause to identify this, and they have different outcomes. Faithful execution includes that word faithful, right? So it emphasizes the fact that there has to be this faithful execution. It qualifies the duty. It doesn't just say you have to execute. The more stripped down execution clause seems rather incomplete because it doesn't have this qualifier, and you could go on with the take care clause and other things. Textually augmented labels. The fugitive slave clause and the spending clause. There's no spending clause in the Constitution, but the government often justifies, legislators often justify their spending, their sometimes reckless spending, by saying, oh, well, we have authority under the spending clause. And then it is, oh, you have a spending clause. I didn't know that. Oh, now I see that that's a legitimate exercise of government power. It's not, right? There's nothing that actually, by providing the label, it starts to justify the existence of this power and the narrative that this is a legitimate way to exercise. Instead of saying, okay, let's look at the taxation clause power and figure out what then are limitations on, tied to it in a more complete analysis there. Functional labels are similar to, what kind of function do things do? We can have editorial choice in labels. These are some that I've already talked to you about. One that I want to mention really fast is going to come up in just a sec, and that's the progress clause. So let me just tell you a couple things about this. Hold on one sec. Sorry. Okay. So let me just stop the share. So the point here is we can put these in a variety of different ways in which the labels are used. We can start to create categories where the labels are used. One of the things I want to stress is that none of this is a long-standing practice, and for that reason, it is not. It doesn't have sort of some kind of historical, long-standing historical basis. Is the share up right now? The screen? Okay. So with that, I think I'll take your questions. Let me just give you one other example, because some of you may be working in the IP space. Strategic labels instead of labels chosen for efficiency of language. One strategic label that is clearly out there right now is the progress clause. And so this is one that is being used by some scholars to say that this prefatory language in the intellectual property provisions in the Constitution, the copyright and patent protection clauses, that language is somehow a limit, that you have to, in order to get a property right in intellectual property, you have to prove that you're actually going to make progress with it. Instead of saying that we grant the rights in order to further progress, right? The granting of the rights themselves further progress. And so it's really just telling you what's the reason for granting the rights in the Constitution. It's not saying that there's this extra layer that must be met before you can actually go forward. So if that's the case, then we see these scholars using progress clause as a means to try and say, no, this is an actual limitation. They're emphasizing this word progress and arguing that it is only to further progress. And so if you can't prove you're furthering progress, you don't get any intellectual property rights guaranteed by the Constitution. Clear strategic use. The other big strategic use, one that's discussed in a chapter in the book, most of the corpus and historical work was done already by Gerard Maglioccia for me in a book called The Heart of the Constitution, which I recommend to all of you, and that's the Bill of Rights. So we all walk around talking about the Bill of Rights, the Bill of Rights, and as it turns out, as Professor Magliosha points out, the label, the collective label for the first 10 amendments of the Bill of Rights was not adopted by anyone, even the founders. It was not adopted by anyone until a couple instances that you can find post-Civil War. And then it really wasn't, though, brought into use until Franklin Delano Roosevelt. And FDR used it for two purposes. One was to justify the New Deal, because he said, you will always have your Bill of Rights. So this is, FDR is the one who put it in the National Archives. FDR is the one who created Bill of Rights Day. FDR, had all these ways in which he used this to say, don't worry about the New Deal and all this new big governmental power, because you'll always have your Bill of Rights. And it was a concentrated advertising campaign for the New Deal that led us to start calling the first 10 amendments the Bill of Rights. True, at the founding, there was a deal brokered. And we said, look, the founder said, and Madison agreed to draft a Bill of Rights in order to satisfy those people who were weary of the Constitution on not having these kinds of rights protections. And so there was this idea that some people thought we don't need a Bill of Rights, other people thought we did. Madison said, fine, we'll draft a Bill of Rights. After that, Madison drafted 10 amendments, but Madison never called them the Bill of Rights. He never called them a Bill of Rights. He just called them the 10 amendments. And neither did anyone else, in part because this sort of clamor for a Bill of Rights went away. And so the first 10 amendments were called the first 10 amendments for most of our history. It was not until the 1930s that they started being called the Bill of Rights, the Bill of Rights. In fact, there's different portions of the Constitution that some people called a Bill of Rights. And the ex post facto provisions and the contract clause provisions were called a Bill of Rights and not the first 10 amendments. You can find publications from the government in the 1920s and early 1930s that still have in their table of contents first 10 amendments. They don't call it the Bill of Rights, right? They label them in these books. So that was a strategic use of a label to try and change the narrative of the kind of project that's happening in the first 10 amendments. And it elevates them to this different kind of status by using that label. I could go on with examples for hours, but I would rather hear your questions. So that's the project. Those are some examples, and I'm curious and excited to hear anything that you all have to say.